And welcome to this edition of Sports in the Courts. My name is Tod Castleberry. I will be your host in this podcast, and I am joined by legal analyst Charles Bonani. Welcome, Charles.
Hey, thanks, Todd. It's great to be here with you in the studio. I'm happy to dive into all these crazy developments going on in this area.
Well, we felt the need to throw our hat in the ring with there's a couple 100,000 podcasts out there, but I think we're going to be the differentiator here because the collision of business and sports and entertainment is some of the biggest business on the planet. And with that and billions of dollars being exchanged comes a lot of legal issues and battles, and nothing bigger than what's been at the forefront here. And with the culmination of the NCAA men and women's basketball tournament here and another exciting round and billions of dollars being exchanged, what better way to kick off this podcast and delve right into a hearing that took place yesterday. Dateline, Oakland, California, U.S. District Judge Claudia Wilkin. And it's really up to her as to what's going to happen if she's going to grant final approval to the settlement between the NCAA, current and former D1 athletes represented by the House, Carter, and Hubbard antitrust litigations. Mm-hmm. So that's a mouthful right there. So give us
you did a great job with it, though.
Thank you. Give us a little historical perspective on how did we get to where we are, and what are those three different groups of litigants that are all now enjoined?
Sure. So the House settlement, it's as you mentioned, it's a consolidation of three separate cases, and they were all various claims that were filed, but they essentially boiled down to antitrust claims filed by current and former college athletes against the NCAA and the conferences. So the ACC, the SEC, Big Ten, Big 12, and the now two-party conference of the Pac-12 RIP. So that litigation started in 2020. That was when the case was filed. And fast forward to where we are now, and the parties in, I believe, May of last year, May of 2024, reached agreement on terms to a nearly $2.8 billion settlement for back pay damages to be provided to student athletes that played college sports between 2016 and 2024. Not only that, the settlement proposal also provided for a forward-looking component that would allow universities to directly pay athletes at their institutions for the first time. And that's
approximately 390,000 class members affected by this, current and former D1 athletes.
Yeah, so those are the estimates. So hundreds of thousands of athletes within this class. But what's notable is the proposed injunctive relief, that's the forward-looking piece, will apply 10 years going forward. So this is basically a new system being implemented by these parties and then being potentially approved by the court to basically, reshape how business is done with these student athletes in college sports.
It's been the wild, wild, wild west with the advent of NIL, and as we've seen it already in the impacts thereof. So it's time to get a handle on this, and that's why this is going to be a landmark settlement, and what amateurism and its previous life will be over.
Yeah, so there will be a lot changing, and just to bring us to what happened yesterday and why we are now sitting in the studio today. Yesterday there was a huge development or a huge event in college sports. And it did not take place on the basketball court, as some people might think. I'm not even acknowledging that a game took place yesterday as alumni of Florida State University.
A little bitter. I feel the bitterness.
I don't need to hear about whoever the team was that won the national championship. Don't even know.
No Gator Chow.
Didn't even watch. I was focused on what really matters, which was this House settlement hearing in the Northern District of California federal court building. But that hearing was a final approval settlement hearing for this landmark proposed House settlement. And so that was the final time that the parties involved basically made their case to and against this proposed settlement being instituted. And so now we are, basically at the end game of this new regime of college sports being implemented.
So yesterday, you had respondents from all three categories of attorneys, athletes, and NCAA representatives, lawyers for the NCAA. Jeffrey Kessler.
Jeffrey Kessler, who's the co-lead counsel for the plaintiffs, for the class.
So Olivia Dunn, from current LSU gymnast who's making millions. She testified via Zoom.
She was, as an objector. Yeah. So Olivia Dunn was one of and she's the, as you mentioned, she's LSU gymnast, has a big following and presence on social media. She testified as one of the objectors, just stating, her issues with how the damages portion of the settlement was calculated. She believes that for, certain athletes such as herself, whose NIL, value is exorbitant, this calculation has undervalued her and other athletes. So she testified. Other notable objectors were Thomas Castellanos, Boston College quarterback, who's now transferred to Florida State. And then there were some other notable objectors as well. But those individuals, whether it was actually speaking in court or filing an objection to the court that the judge read and considered, were part of what was heard yesterday.
And you brought up an excellent point, because what is really important to understand here, this is only about the antitrust litigation. This has nothing to do with Title IX and some of the other things that will be litigated in the future. But once she makes a ruling on this, and it sounds like, and this is where I want to get your interpretation based on all the testimony she heard and the back and forth, that I think the overwhelming feeling is that she is going to rule favorably, with some asterisk where she has tasked him to go back and consider some changes.
So I think so. So most observers of this litigation and of the hearing yesterday, I think, would expect that this settlement will ultimately be approved. She granted preliminary approval a few months ago, back in the fall of 2024, which was the first step in this settlement approval process, and that was a big hurdle at the time that indicated that this was likely to get approved. And nothing in the hearing yesterday, I think, gave anyone reason to think that things would be derailed entirely. But as you note, there were a couple components that Judge Wilkin wants the parties and the counsel for the parties to look to and focus on. And there are two key components that she harped on. One is the new rules surrounding the removal of scholarship limits and in place the implementation of roster limits. That probably is the piece of this settlement that has the most amount of opposition to it. And that's because under this proposed settlement, there will for the first time be a roster limit that is capped at, I believe, 105 per, at least in football.
College football.
In college football, it would be capped at 105, which is notable because the average roster in college football last year, I believe, was 120, something around that. And that roster limit is higher than what the previous cap was on scholarships, which for football was in the 80s. But it now is this new overall roster cap. And so there are some, student athletes that are at risk or might have already been told by the university that they are not going to have a roster spot that was otherwise promised. And so Judge Wilkin has taken a little bit of issue with that, and she has asked the parties to look into whether or not existing players on university teams that could be at risk of losing a roster spot should be grandfathered in.
Right.
And I think what's important to note here is Judge Wilkin's authority here is somewhat limited. Under the way class action settlements are approved like this one, she has to determine whether the settlement is fair, adequate, and reasonable. she can't come in and take her pen to the settlement agreement and rewrite it and say, okay, here's what you all are agreeing to now. It still is a settlement agreement between private parties. But she can say, hey, I strongly would urge you to look into making these changes. And, I think that's something over the next week or two these attorneys were going to do. So the grandfathering in of the roster spots is one area that she's asked them to consider. And the second area is asking them to look to how the settlement is going to be imposed on future athletes that aren't yet enrolled at any university. So, for example, your sixth grader who is playing baseball right now in Little League.
Well, isn't this the conundrum that she is under, in the sense of she's trying to approve something that corrects the sins of the past, takes into account the folks already in the system, and looking forward. So she's got three different missions here she's trying, and I think that's what her mindset came back with yesterday in tasking these different folks to kind of hopefully reduce future litigation.
Yes, reduce future litigation, but also just ensure that the current settlement is fair to those future to future parties, and potentially even increase litigation by allowing future parties the opportunity to have their voice heard if they think for some reason that the settlement is unfair as applied to them, or unfair more broadly. And so she's asked counsel for the parties to look into whether there's like some modifications that can be made to more adequately address how this sort of future classes will be defined. Those are two pieces, and I don't think anyone expects that they will blow up the settlement. I don't think, even if the parties come back without substantial changes in either of those two pieces, that Judge Wilkin will conclude that the settlement isn't fair and reasonable. I have a quote from her from the court, and I'd like to quickly shout out all the sports reporters that were in court tracking everything that was going on. I am here on the other side of the coast, was not able to be in the court in person, and so we have to rely on those reporters that are providing that on the ground coverage and posting it out to the world. So thank you to those. Judge Wilkin was quoted as saying, basically, I think it is a good settlement. Don't quote me, and I think it's worth pursuing. I just quoted her, but I think, she obviously wanted to provide the qualification that that doesn't mean she was approving it then and there, but
she likes what she's hearing.
The writing's on the wall for it being approved, and so that with these two little kinks to be worked out, it probably is on track in the next few weeks, I would say.
And correct me if I'm wrong, but she can make her ruling when she's satisfied at any time. There isn't a specific timetable, but it's the ball's back in her court, so to speak. She can make her final ruling, and this would apply for the 25-26 academic year moving forward here, which I believe starts July 1st.
Yes. So the settlement is on, if it receives approval, it will go into effect for the following academic school year, which begins July 1st. So we are talking about just a few months away from this new revenue sharing model being implemented.
So talk about the revenue sharing model, and
it's what we're here to talk about.
I mean, again, this is the end of amateurism. You saw the phenomenon in the last year and a half. You had a lot of different folks from people that worked at ESPN to NBA players now that are becoming general managers at these universities because they're just ripping the Band-Aid off. Give us the breakdown of what this salary cap looks like and what are the mechanics behind it.
Sure. So without getting into too much of the math, because I don't think anyone here wants to hear that. I don't want to try and do it. That's why I went into law. That's the joke that every lawyer loves to say is, we don't know how to add or subtract or divide, and so we became lawyers. But There is a methodology for calculating the salary cap that will be used across all schools that implement a revenue sharing system with their athletes. And the way it is calculated is it is 22% of the average revenues that are based off of across all Power 5, now 4 conferences, schools within those conferences, the average revenues across those conferences for a particular number of revenue sources, such as ticket sales and media rights. Those would be the big ones, but then also distribution that come out from the NCAA for bowl games in college football, for example, and other revenue sources like that. And so there is this methodology that applies over 10 years, year after year, and in this first year, the estimates are that number will be $20.5 million per school. So each school will have up to $20.5 million to spend on their rosters.
As they see fit.
As they see fit, yes. And so this is a key point. Whether or not to actually implement this system is a choice for the schools. They do not have to provide them anything under this settlement. They can. So there's a ceiling, but there is not a floor. So yeah. So I think what's important to note here is two things. First is that schools do not have to choose to pay anything under the system. They can just choose to not implement a revenue sharing system. It is at the discretion of the schools. And so there is no floor that schools are required to implement. There's just the ceiling. So they can implement up to 20.5 million, but if a school that doesn't have many or maybe any revenue generating sports just says this is not something we want to allocate our resources to, they can choose to do that.
That is a very, very key and interesting point, because again, we know about the big boys in the big schools and the fabled programs of men's football and basketball and women's basketball. So that to me is one of the most fascinating things out of this potential settlement.
Yeah, and I think that is the piece of all this that I don't think anyone really knows how it's going to play out exactly. There is a lot of hand-wringing about what this is going to do, what this isn't going to do, how this is going to disrupt competition in sports, in college sports. Whether this is bad for competitive balances. But I think it remains to be seen how, once this new system is in place, how each school chooses to implement it and what this really looks like across the board. I mean, remember, there are, if I get this number right, 363 division schools with Division I sports.
D1, yeah, that sounds right.
So there's a lot of different, I think, area or a lot of different ways in which this could play out, and a lot of different, I think, categories of approaches that you could have for schools. Obviously, people are focused in on the big four conference schools, but and the big sports, football and then men's and women's basketball. But this is going to have implications across all D1 sports in ways that I think we don't quite understand yet.
Well, there's no question that's the big feeling that a lot of folks with March Madness, when your 4 number 1 seeds, there were very few upsets. There's very few, and everybody wants to point, and I think it's a valid point of, listen, the rich get richer. A middling D1 team, then their star player, he can leave because he wasn't getting any NIL money, and he can go be the 4th or 5th or 6th man at a Kentucky or whatever, and so there's no loyalty to the program anymore and that's the part that's really going to impact the alumni and the students every year now, because of the professionalism that comes with that. Seeing these guys develop and they're your guys, it's going to be a thing of the past.
Yeah, it's definitely become a thing in the past since the transfer portal rules have been opened up. Guys are just going from school to school
Highest bidder.
every year.
That's the free market.
And I think the expectation is that these Power 4 schools, your Alabamas in football, your Floridas, I finally acknowledge their existence now. They did win the national championship yesterday. I'm not upset about it at all. But those types of schools, the expectation is they're going to probably put almost all of that $20.5 billion into their big programs. Mm-hmm. But what's interesting is what will happen to these schools that have an outsized portion of their revenue generating sports in one sport. Like Alabama has a very competitive football program and a very competitive basketball program. Are they now at a disadvantage compared to other Power 5 schools that are only competitive in, say, basketball? And don't really let's just throw out a Maryland, for example. There was a lot of consternation over their coach that just left. He had a lot to say about their school's approach to NIL, and I think there's some internal strife over how that school and that athletic department is focusing its resources between football and basketball. So these are decisions that these schools are going to have to make, and I don't think it's going to be something that is going to have clear cut.
But we haven't even talked about, and correct me if I'm wrong, is NIL and the collectives and boosters. That's a war chest that can be whatever.
So that is a very interesting piece of the settlement. You're right. We have not talked about it at all. Part of this settlement is actually an attempt to gain some sort of control, not control, that's the wrong word, but transparency, I would say, and legitimacy over the role of these boosters and these collectives. And so
I saw the big $600 number that they were floating out there as to that's going to be the baseline level for transparency. I mean, explain that if you would, because I got a chuckle out of that.
So the $600 figure, any NIL deal over $600 that a student has to be reported. That
has to be a joke. Is it really an NIL deal if it's only $600? I mean,
well,
what are we talking about here?
Well,
a $600 deal for NIL is lunch money.
So if it's less than that, it doesn't have to be.
Whoa!
reported.
Thank goodness.
If it's
they got to declare taxes for their tips. I mean, I just found that to be laughable.
If someone wants to give me a $600 NIL deal, I will take it.
And with all due respect, you're not playing major college football, basketball.
Listen,
maybe some of the baseball guys that would be happy with that, or whatever. Your lesser sports, I get it. But this isn't about the sports that aren't the revenue-generating sports.
When I played club hockey at Florida State, if they would have given me a $599 NIL deal, wouldn't have had to disclose it under these current rules, I would be rich. I would be feeling great about that. But going back to those bigger NIL deals, so if it's over $600, it has to be reported. But to your point about just how minimal that $600 amount, this is part of the settlement's effort to increase transparency and, in their mind, legitimacy in these NIL deals with boosters and collectives. And so under this settlement, any NIL deal with what they term an associated entity or individual, which is the booster or the collectives that are so notorious in college sports, those NIL deals have to meet two primary requirements. The first one is they have to be for a valid business purpose, which means there has to be something such as a marketing initiative or some sort of good that they're selling.
I want you to sign 100 pictures for me. I want you to sign jerseys. Yeah. I want you to make a personal appearance. That's easy.
Yeah, and it's right. Then what is a valid business purpose, right? That's inherently a subjective inquiry. The second one is that it has to be the amount paid. It has to be fair market value for the comparative value of that student athlete that's getting the NIL deal. That would be compared to someone similarly situated that isn't a student athlete.
But that is completely subjective.
Right.
And I saw that they're also going to take professional athletes look at their deals and compare them to NIL. It's okay. So I guess the question is the framework in which to establish what real value is. The Livy Dunns, the Shadur Sanders, they go, okay, they got this many people following them on here. Here's the impact they have when they play and they do something. All calculable. There's plenty of agencies that do all of that stuff. So the framework exists.
The framework exists, and the conferences, the Power Four conferences, have already taken steps to engage an auditing firm to conduct those calculations.
It's professionalism. It's here. It's real. And for those that want to go back to the rah-rah sis boom bah days, and we're doing it for our old alma mater. Sadly, those days are gone. We saw this day of reckoning coming, and I think hopefully they get a handle on. You got to really just be clear on what the rules and the regulations and how this is going to operate, so that transparency is a good thing moving forward here.
Yeah.
And see where it goes, because the money is so great.
And what they're really trying to do with these boosters and collectives rules is try and prevent these more well-resourced schools from circumventing this new salary cap. So they don't want the Alabamas of the world, saying, okay, our star quarterback, he'll make a reasonable amount under the $20.5 million revenue sharing salary cap. But, oh, by the way, on the side, here's this booster that's just going to, pay you $10 million a year to do nothing other than play for the University of Alabama. I think, the fascinating piece of all of this is, how is this going to play out in practice? Because we obviously know that these boosters and collectives are, and the resources that exist are being used as recruiting tools, whether we want to, acknowledge it as such or not. But I think what the House settlement is trying to do is say we understand that that's happening, but we want there to be some sense of legitimacy to these deals that isn't just here, pay to play entirely. There has to be something in terms of the likeness being provided by the athlete that the third party is getting in return.
I don't see a problem with that. I think that's actually going to be an easy part of the equation here. The one thing that's not going to change, which is why we love college sports so much, because it's part of our identity and where we go and who you root for, you're passionate for. And it's always been based on, the alumni and your donor base and your booster clubs. And this is just going to make it more transparent, which I still continue to believe the rich are going to get richer. But there's going to be that rising tide's going to lift all boats here, and that's going to.
Yeah, I think there's a lot of opposition to the settlement based on concerns that it's going to, even make the competitive balance in sports worse. Number one, there already was an immense competitive imbalance in college sports. I think the Jeffrey Kessler, co-counsel for the plaintiffs, has been making this case very bluntly. He said college sports has never had the parity that professional football has, for example, and it likely never will. There's just too many different variables that make it different. Should we always be trying to increase competitive balance? Yes, I think that's good for sports and good for competition. But anyone who has watched, this past March Madness, prior to that, UConn men's basketball team won 2 times in a row. In football, there is always a dominant powerhouse, and it shifts between, a couple schools between the SEC and the Big Ten, and every now and then an ACC team. Maybe once upon a time it was Florida State, not so much anymore.
Long time ago.
Long time ago, unfortunately. But that competitive imbalance, has existed, and I think this settlement is a pretty reasonable attempt to try and both increase transparency in college sports, but also create some sort of uniform rules by which all D1 schools are.
Got to have the framework, got to have the architecture, got to clean up the mess. And we will end it on that particular note, Charles. A lot of great information imparted here. We will keep an eye on this and the offshoots that will come off of that as discussed, because judge has to make her ruling, and I'll bet you it comes down sooner rather than later based on how much she's been leading off of first base and what she's been indicating here. So we will keep everybody posted, and we'd like to thank you for tuning in and join us for Sports in the Courts.